Friends, on this episode, I want to share with you what your options are if you have not received a decision on your case or your case is stuck without an interview and you're stuck abroad or even in the United States without legal status. I want to go over your options. If you're experiencing long delays in your case, you need to get it moving to get an interview or decision. Friends, welcome to Green Card Guys TV. I'm your host, John Ting. I'm a licensed immigration attorney helping immigrants and companies in all 50 states of America and across the world, helping you solve your immigration problems. We release new videos with tips every week. If you're new to the channel, welcome, and go ahead and subscribe down below and click the notification bell so you get all the free tips in the future. You might be wondering if your situation is common or rare. Unfortunately, it's most likely common. Are you stuck outside the U.S. either waiting for an interview or already had the interview at the consular embassy? Maybe you even received a 221G notice. Or are you still waiting for an interview in America or already had the interview for adjustment of status or asylum and you're still waiting for a decision in the mail? These are common scenarios, common situations when we file a lawsuit based on unreasonable delay. You deserve your legal status. There is no reason to wait anymore. Go to our website to download the free guide about Mandamus actions so you can learn more about it. Comment below how long you've been waiting. We are here to guide you to solve your immigration problem. Does 221G notice mean my visa is denied? Yes and no. You still have a chance to bring it back alive. A visa denial under Section 221G of the immigration law means that an officer did not have all the information required to determine if you're eligible to receive a visa. It could be a number of reasons. But this means you're not eligible right now, but your case is pending further action for one of two reasons. Number one, your application is incomplete and further documents are required. This can also mean refused. The officer will inform you what is required, so they'll provide you a document. And number two is administrative processing of your case. That could mean that if it's an employment-based case like H-1B, they need to do a site visit. So essentially, this typically means that your case is going into a black hole or a sand trap because essentially they typically forget about the case, unfortunately. So here's a tip. You need to provide the documents to the officer or the consulate as soon as possible. Now, if it's been at least 2 or more months and you're still waiting, some people actually call us after about a year and they're still waiting, it's time to sue. Don't let the government take advantage of your case. Here are the steps when we file a lawsuit. Step number one is we want to make sure you're eligible to file a lawsuit because not everyone's case qualifies. It could be too early, but the best thing to do is give us a call so you have a better idea. Now, after you hire, we file a lawsuit complaint against the appropriate U.S. immigration agency. It could be Department of Homeland Security, USCIS, the local field office, or even State Department. Depends on your case. Then we mail it physically to each agency. That's called service. After the government receives it, they have 60 days to file an answer. Now, don't get this confused with a response, meaning there's not going to be a reason why your case delayed. We already know what it is. The answer does not mean that you'll receive the outcome you're seeking. Okay? It could take some time. Now, answer in this situation means a legal procedure notifying the judge, the court, that the government denies all allegations. However, U.S. attorneys do not want to file an answer, actually. They actually want to help you. Now get this. They'd rather focus on cases such as like white collar crimes, like maybe Donald Trump type cases. Now here's the thing. We usually get results that we want within about 30 or 60 days after we sue the government. It just depends on the type of case. But we cannot promise for you. Give us a call to find out if you qualify. People ask this all the time. Will suing the government immigration agency result in my case being denied? Yes, it's surely possible, but if the government was going to deny your case, they would have done it already. They would not let a case just sit there. Then you might ask, why is my case being delayed then? Without an interview, without a visa issuance, or even the green card. The government agencies are not efficient. Less people are working, and the pandemic made the problem 1,000 times worse. Actually, 500,000 times worse. Delays were happening even before the pandemic. I know it seems strange to sue the government to force them to push your case to the next step, but yes, our law firm is successful in getting results that you deserve. Don't let the government take advantage and be lazy about your case. Specifically for a fiancé visa case that was approved, the petition was approved, but was stuck at the National Visa Center. Now, our client called us frustrated that his fiancée was not able to get an interview scheduled at the Manila, Philippines embassy. They'd been waiting for 8 months. And you know what? We ended up suing the government at the 1 year mark and pushed the government to schedule an interview. Now, this happened about 4 months after we filed the lawsuit. Our client was scheduled for an interview, and better news, she was issued the visa, the fiancé visa. So now she can join her spouse or soon to be spouse and get married and go ahead and file the adjustment of status application for the green card.